1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်664ဒေါ်မင်း and 1 appellants vs ဦးသက်တင် respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Second Appeal before ဦးကျော်စံဦး Judge ဒေါ်မင်း and 1 appellants vs ဦးသက်တင် respondent Suit for adjustment from the land res judicator landlord losing his first suit to recover possession of property based on his bona fide requirement for construction of a building, chain of circumstances, whether the second suit is barred by res judicator. The respondent find a suit against the appellants for adjustment from the land and was unsuccessful. Then he find another suit out of which the present appeal arose. Hell, it cannot be said that once a landlord has lost his suit to recover possession of his property based on his bona fide requirement for construction of a building on the ground that the requirement was not bona fide because he had no innate means to construct, he shall forever be precluded from instituting a fresh suit because of res judicator. The second legal notice date the 3rd September 1962 terminating the tenancy for the second time exhibit Samyensue give a fresh cause of action in the former suit. The trial court drew its inference that the requirements was not bona fide not only from the fact that he had no means but also from the fact that the respondent had not applied to the municipality for permission to erect a building, though he had put out a plan, but in the present case, he had found the permission he obtained from the municipality, exhibit Sagwe. The facts obtained in the suit now under consideration are not quite identical with those in the previous suit, though the relief claim in both the suit are same. When the circumstances have now changed, res judicator cannot find a place in the suit. Anti-Call Fast MG River ILR 1951 Boom 310 Barman Fast Woods 1948 IKB 111 refer to Umya Singh for the appellants, Utin Mao for the respondent. Ujo San-u, Judge, this is an appeal against the judgment and decree of the Additional District Court of Mandalay, confirming the judgment and decree of the Additional Township Court of Mandalay in Civil Regular Suit number 205 of 1962, where the respondent obtained a decree permitting him to erect a building on executing a bond in the sum of 2000 on holding number 76, block number 558. In Aunanjeta Alebai, Mandalay, within 1 year from the date of vacation of the premises by the appellants, who are husband and wife, after dismantling the present structure standing thereon with a note made by the court that so long as the general direction of the chief court that no execution for evasion from the lands and buildings should be made until further orders stand and is in force, the decree should remain ineffective. It was a suit for adjustment from the land instituted on the 18th October 1962 on the ground that the respondent bona fide required the land for construction of a house for residence, as the house where he was residing then was merely a temporary hut. He stated that he had already made a contract as per Exhibit Saleh, date the 18th June 1962, with the carpenter Ko La Ngui, plaintiff witness 2, for the construction of the house. He claimed that he inherited the land from his mother, who leased it to the appellants at $15 per man on condition that they must vacate the land and the house whenever he desired them to do so. The suit falls under Section 12(1)(d) of the Urban Rent Control Act 1960. The appellants stated in their joint written statement that, with the permission of the respondent mother, they had erected a house worth $2,000 on the suit land. They admitted that the land belonged to the respondent, but denied that he bona fide required it for constructing a house for residence, as his present house is a substantial building. They stated that the respondent mother orally permitted them to stay on the land at $15 per man, so long as they wanted. They do not deny receiving the legal notice date the 3rd September 1962, Exhibit Samyensue, terminating the tenancy on the 13th day of September 1962, as the respondent desired to erect a building on the land. The third issue, whether the respondent required the suit land bona fide, loomed large in the trial court, which answered it in the affirmative. On this issue, the lower appellate court concurred in the finding with the trial court and upheld the answer. This is concurrent finding of facts, and no second appeal could have been preferred. But the appellants had raised a point of law for the first time in the lower appellate court that the suit was barred by res judicata, and this is the only point now taken up in this appeal. There is no dispute that a similar suit was filed by the respondent against the appellant in civil regular suit number 217 of 1960 of the Township Court of Mandalay on the 26th August 1960. The two plaintiffs are same verbatim ad literatim, with the exception of the addition of a paragraph in the latter suit, out of which the present appeal arose, stating that a contract had been made with the carpenter for the construction of a house, and the plan had been approved by the municipality. The only difference in the two plans is in the dates given for the cause of action. In the former suit, it was stated that the cause of action arose on the 31 July 1960, that is, the date on which tenancy was terminated by a legal notice, Exhibit Nga, in that suit, and in the present suit, now under consideration, it was stated that the cause of action arose on the 30 September 1962, which was the date on which the tenancy was again terminated by a second legal notice, Exhibit Salon. It is apparent that the tenancy was revived by the parties when the first suit was dismissed with cause Otherwise, the second notice would be superfluous. In the first suit, also there was an issue on the bona fide requirement of the land by the respondent for the construction of a building, and the court held that the respondent, being a tailor, had not a net means to construct a house, the daily income being just 2 to just only, and that he had not applied for permission from the municipality to erect, though he had put up a plan of the house. The present suit, now under consideration, was instituted barely 5 months and 17 days after the dismissal of the first suit. The lower appellate court held that, in the instant case, the question of res judicata, being a point of law, could be raised, and the suit is not barred by res judicata, as the cause of action is different from the one in the previous suit. The facts are not in controversy, so a new plea could be entertained on appeal. Which were net right first, Kashi net right 1. When a question of law is raised for the first time in a court of last resort, upon first either admitted or proved beyond controversy, it is not only competent but expedient, in the interest of justice, to entertain the plea. Connecticut Fire Insurance Company vs. Carvanash 2. This authority was followed by the Privy Council in M.E. Mola-San Limited in liquidation vs. Bajaji 3. The same view was held in Isaf Golan Mohan Piradi vs. Arif Mohan Ben and 1. 4. Ubaji vs. Domi A. Mrs. Ko Sain Ban 5. Haji Abdul Shakur Khan vs. The Burma Publisher Limited 6. In Shio Kayan Sin 2 Suya Yane Sin Par 2 7. Decided by a bench of 3 judges of the Chief Court, of which I was a member and had the occasion to write the judgment in Burmese. The only important point raised for determination in appeal under Section 5 of the Union of Judiciary Act, and unfortunately failed to catch the attention of the editor of the Burma Law Report to flash it in the headnote, was that, since the question whether the estate was a Hindu joint family property or not had previously been decided in a formal suit between the parties, the same question could not be raised inasmuch as it was not raised in the original suit, and in the first appeal, out of which it rose, the bench considered the point and gave decision that the appeal was barred by res judicata, in spite of the fact that, as the decision in the former suit was under appeal, the point could not have been taken up in the original suit, and also in the first appeal, out of which the appeal under Section 5 of the Union Judiciary Act, which the bench was considering, arose. In view of the authorities mentioned above, it must be held that the question of res judicata could be raised on appeal, though not taken up in the original suit. Now I come to the second point, whether the suit is barred by res judicata or not. I do not quite appreciate the contention that once a landlord has lost his suit to recover possession of his property, based on his bona fide requirement for construction of a building, on the ground that the requirement was not bona fide, because he had not annexed means to construct, he shall forever be precluded from instituting a fresh suit because of res judicata. He might be poor then, but if he later acquire means, for example, by winning a first prize in the state lottery or by being promoted to a higher service due to his sheer hard work and honesty, the circumstances had undoubtedly changed, giving rise to a fresh cause of action to find a new suit for the recovery of possession on ground of bona fide requirement to construct a bigger or a substantial house for a better living. I'm of opinion that the second legal notice date, the 3rd September 1962, terminating the tenancy for the second time exhibit 三年罪, give a fresh cause of action. In the former suit, the trial court drew its inference that the requirements was not bona fide, not only from the fact that he had no means, but also from the fact that the respondent had not applied to the municipality for permission to erect a building, though he had put out a plan, but in the present case, he had found the permission he obtained from the municipality, Exhibit Sagwe. I agree with the lower appellate court that the facts obtaining in the suit now under consideration are not quite identical with those in the previous suit, though the relief claims in both the suits are same. When the circumstances have now changed, I do not think res judicata finds a place in the suit. In N.J. Corvus, M.G. River 8, Chagala C.J. was of the opinion that when the question of the landlord reasonable and bona fide requirement has already been decided, the decision becomes final and conclusive, and the landlord is given the right to re-agitate the question only when new circumstances are put forward by him in a subsequent suit. In Burma v. 9, it was held that as chain of circumstances may occur from day to day, the principle of res judicata is not applicable. B.B. Das Gupta, in his book on rent control as an orders, 2nd edition at page 35, quoted this authority under the heading res judicata if applies to suit for a judgment on grounds of reasonable requirements in the result the appeal phase and is dismissed with cause. Advocate fee, J. 85.